Exactly.
Some people will say, well, I don't have anything, why do I need a will? And I always use that example.
Yes.
Somebody hits you, runs you over with a bear truck, what's going to happen? That's going to go to any relatives that you may have. If you're married, it goes to your husband or your wife. If you're not married and you have children, it will go to your children, so on and so forth.
Right. And also, who's going to control the claim? Who's going to bring it to court for you?
That's right.
If you know who you want to control your affairs, that's listed in the will. If you don't have a will,
The executor.
The executor. And we can talk a little bit about that. I just wanted to finish up on what you started, the path you started us down with, how can you avoid probate. You started talking about joint names on things avoids probate. And the reason it does is because of what we talked about. You don't have to change the name on the asset because it already has someone named. It can be done with a house. Many times if a husband and wife are the only people who are involved, and there's not a lot of assets, so you're not looking at avoiding tax issues, you could put their names on everything and avoid probate. You'd still want to have a will for the reasons we just talked about.
Yeah. If people say, I'm married, I live in this state, my spouse owns 50% of everything anyway, is that a good enough reason not to go through whatever it takes to put together a will or have an estate?
I think it's always advisable to have a will. I mean, I don't think there's ever a good enough reason not to have a will. You can go to Staples and buy a very simple, or you can even go on the internet and buy a will, as long as it's signed in front of two witnesses and notarized.
The affidavit would be notarized.
Yeah, it has to be notarized in the presence. It has to be signed and witnessed in the presence of a notary. So it can be very simple. It doesn't have to be complicated.
I know that was one of my questions actually, because online certainly makes it seem as though it's easy, but to make sure it's valid, you were trying to explain a couple of those points, except there are people who want to, I don't know, maybe they feel cheated or that person wasn't of sound mind. If you have a will, all of that, does that mean you can't challenge? It can't be challenged? Does that mean that someone's free and clear? Because you could always make an issue,
A will
could you
can
not?
always be challenged. There was actually a very good John Grisham book,
That's
if
right.
you like John Grisham,
Yeah.
where the fellow executed the will on videotape so that he could avoid having people challenge it afterwards. So even the videotape deposition of a will, the videotaping of a will and trying to do all that gives you some really good evidence, but it doesn't mean someone can't come in and challenge it afterwards.
And if you're going to challenge it, you have to have good cause.
Right.
So you have to show that the will was administered or executed as a product of coercion or duress. It's just
Sticky.
if you're not happy with what you have,
Right.
you just can't go in there without a good reason to challenge your will.
Mental capacity,
Yeah,
for
mental
example.
capacity.
And that is true also if someone did have the presence of mind and enough assets that made them think that they needed to put together an estate or have an actual estate, that too could be challenged?
Like I said, you can challenge anything. It doesn't mean you're going to have any success in your challenge of it. It's a lot of issues that go into testamentary capacity and fraud and coercion and all those things. And there's a presumption, again, that the person knew what he was doing, or she, and that they followed the rules so that the will itself isn't defective because of lack of witnesses or whatever. And therefore, the burden's going to be on the person challenging the will.
Which is why you always have to have witnesses and your notary present.
Right.
Because they can attest to the person being of sound mind and capacity.
You sit here as two attorneys. I'm sure you've handled wills. I'm sure you've done estate planning. And yet you do point out that there's the availability to get it at a library, to get it online. Certainly that's cost saving. Why should someone think about using an attorney? And what does it cost to do a simple will? Say for the sake of argument it's under $25,000 and fairly straightforward.
Because you should use an attorney for several reasons. First of all, the cost isn't that much if we're talking about a very simple will plan. And the will, to be honest with you, as another colleague of mine has said, is not the most important document you want in an estate plan. Probably the power of attorney is the most important document.
So when we do an estate plan, we provide for the client or clients a last will and testament, a durable power of attorney, and a healthcare power of attorney, or known as a healthcare proxy in mass.
Right.
And I'll let David finish.
Well, they cover two different things. The healthcare power of attorney is for your healthcare decisions. And those come into focus a lot when you have cases like the young lady in Florida who was terminally ill, and the parents, I believe,
Terry
maybe...
Schiavo.
That one too, and there was one before that. But in any event, lay out what you want your family to do so the burden's not on them to try to figure it out. That's what a healthcare power of attorney does. It gives some advice, some direction, and it names the people who you know will carry out your decisions on terminal healthcare issues and healthcare issues in general. The second document, the power of attorney, is a financial power of attorney to determine, I have a house, I may want to sell the house, and now I can't do that because of my physical health. Name someone who can do that, someone who can go to the bank for you, someone who can deal with life insurance policies, someone who can deal with creditors, any of those types of things, anything that you could do. The importance of that document is it avoids the necessity for a guardianship should you become incapable of handling your own affairs.
The other thing, too, is we have to really explain to clients that the power of attorney and the healthcare power of attorney is only valid while you're alive, because the minute you decease, it's no longer a living document, so to speak.
And that's where the will would take over.
That's where the will takes over.
So when you talk about a power of attorney, is that likely to be the same person who is the executor of the will?
Well, that depends.
Explore the options.
You have an unlimited ability to decide who you want to take any role in a will in the power of attorney. You can name two people to be power of attorney. You can have them act singly or jointly, require it. Sometimes when I have clients with just two children, they want both children to be on every decision. That can be cumbersome, but at least they know what's happening is what they want to happen. Again, in a will, there's more than just the executor sometimes. Sometimes if you have young children, you want a trust, a testamentary trust in the will. You might have a separate person be the trustee, and you might have another person be the guardian of your children. These are all issues. The reason I say you should always consult with an attorney, there may be a number of issues that you haven't even thought of.
Tax issues.
Tax issues. Who's going to take care of the children? How should there be a trust? Do I need a trust? A lot of issues that can come up that, sure, you can have a form that you can just fill out, but it doesn't give you the advice that an attorney would give you.
What happens with a person who dies who wants his estate or his money, her money, to go to the child, not to the spouse? Is that an issue that a will takes care of without one of them challenging?
Statutory share.
Well, you come into some very interesting issues there.
A spouse has a right to take what's called a statutory share or statutory election, which means if I'm married to David and I don't like him today and I disinherit him in a will, well, when I pass away, he has a right to either waive the will and collect or receive what he would from my estate as if I died without a will, which is called intestate. Or he can file the will, but if he files the will, what do you got? Nothing.
Right. So here's what happens in Rhode Island. If you die without a will, and some people say, why do I need a will? I have a wife, I have children, I know what's going to happen. Well, do you really? Because if you die without a will in Rhode Island, and Jackie can talk to this better than I can, but if it's real estate, the real estate doesn't go to the spouse. It goes to your children.
Because?
That's what the law says if you die without a will.
It goes into a life estate.
Subject to the spouse's life estate. So they own it and they have the right to use it while they're alive, but they can't sell it and move to Florida if that's what he or she wanted to do, because the children would have to agree to sell it too.
This is prickly.
Because they have the remainder interest. And money, personal property, that doesn't all go to the spouse either.
No.
I believe it's split.
Personal property, half of it goes to the spouse, the other half goes to the children. Now, where it gets even stickier is if you have children, if your spouse dies leaving children from another marriage, and there are no natural-born children from this marriage. That's where it really gets hairy. So it
can be very complicated.
Therefore, that's why you need a will.
Exactly. That's why you don't want to rely on the intestacy laws. A lot of people come in and say, I don't want my property to go to the state. Well, it almost never goes to the state. That's called a cheating or sheeting to the state. That doesn't happen because they go down a long list of relatives before anything like that would even be possible. The problem is, if you have some property, maybe you don't want it going to your fifth cousin from some other place. You want it going to where you want it to go.
And if you do have more complicated families, as many people do these days, is that a very good reason in and of itself to not have a will, but perhaps have an estate which isn't open to the public to have other people look at and check what's in it and not in it?
It would be